Hello everyone, my name is Lakshmi Priya. Today we'll deal with the third chapter of Indian polity by M. Laxmikanth, that is Salient Features of the Constitution. So in this session we'll be dealing with all these subtopics. Okay, total there are 17 subtopics. First we'll start with the lengthiest written constitution. So we all know that our constitution, Indian constitution, is a written constitution. See, originally in 1949 the constitution contained a preamble, 395 articles that were divided into 22 parts, and 8 schedules. So originally when the constitution was formed in 1949, only a preamble, 395 articles and 8 schedules were there. At present we have 470 articles which are divided into 25 parts and 12 schedules. Now let us see some of the features that resulted in the lengthiest written constitution. First one is geographical factors. To fulfill the needs of the people, the makers of the constitution drafted many laws. They included many laws in the constitution, and that resulted in the lengthiest written constitution. Next is historical factors. See, we all know that many provisions of the constitution were taken from the Government of India Act of 1935. From this we have taken a lot of provisions and included in the present day constitution. Next is single constitution. We have the whole India has only one constitution. Okay. Next, dominance of legal luminaries in the Constituent Assembly. Okay, legal luminaries. Example is Dr. B.R. Ambedkar. Okay. Next, we'll see the drawn from various sources. See, Dr. B.R. Ambedkar, who was a major contributor in the drafting of the Indian Constitution, took help from multiple sources. Okay. So Dr. B.R. Ambedkar, he proudly said that our constitution was made by borrowing important features of different constitutions of the world that were present at that time. Next, the structural part of the constitution is to a large extent derived from the Government of India Act of 1935. Okay, the structural part is GI of 1935. The philosophical part of the constitution, that is fundamental rights and DPSPs. Okay, fundamental rights is taken from the American Constitution and DPSPs are taken from Irish Constitution. Next is political part, is taken from the Britain. Okay, next we'll see the blend of rigidity and flexibility. Constitution of India is neither rigid nor flexible, but synthesis of both. Okay, rigid is an example of USA Constitution. Flexible is Britain. But ours is combination of both. Okay. Next, Article 368 provides two types of amendments. Okay, one is special majority. Special majority, that is 2/3 of present and voting. Majority of 2/3 of present and voting. This is first one, and next one is 2/3 of present and voting plus ratification of the states. Ratification of the states. That is more than 50% of the state legislature should accept the law with a simple majority. Simple majority. Okay. Next, we'll see the federal system with unitary bias. Federal structures. Okay, federal features. Written constitution, two governments, that is center and state government. division of powers. That is, see, in 7th schedule we have union list, state list, concurrent list. Okay, center can make laws under union list, states can make laws under state list, both center and state can make laws under concurrent list. Next, supremacy of the constitution. Bicameralism at center, okay, not at state. All states doesn't have state legislature and state legislative councils. So bicameralism at center. Next, rigid constitution and independent judiciary. All these are the federal features. Next, we will see the unitary features. Strong center, single constitution, emergency provisions, single citizenship, all India services, appointment of governors, integrated judiciary, and so on. Okay, all these are under unitary features. Next, the Indian constitution is unique in that it is a novel type of constitution that combines the attributes of unitary and federal government rather than being a true federation. Okay, see, in the constitution there is nowhere mentioned as federal. Federal is nowhere mentioned. So in the constitution we have union of states. Okay, next we'll see the parliamentary form of government. See, there are two, parliamentary and presidential form. Okay, parliamentary system and presidential system. Now let us see what is parliamentary system. It is based on coordination and cooperation between legislature and the executive organs. Okay, parliamentary system is a coordination and cooperation between legislature and executive organs, while presidential is based on doctrine of separation of powers. Okay, there is no link between legislature and executive in the presidential system. Now we are following the parliamentary system. Now let us see the features of the parliamentary form of government. First is nominal and real executives. Nominal is president, real is PM. Next, majority party rules. Whichever party secures the majority of the votes, they are going to rule. Next, collective responsibility of the executive to the legislature. So executive who make laws are responsible for the legislature. Next, membership of ministers in the legislature. Leadership of the PM or a chief minister. All these are the forms of parliamentary form. Next is dissolution of lower house. So 5 years, maximum of 5 years term of lower house. Okay. Next we will see the synthesis of parliamentary sovereignty and judicial supremacy. The Indian Constitution's framers preferred a proper synthesis of British principle of parliamentary sovereignty and American principle of judicial supremacy. Okay, our Constitution framers, they synthesized both parliamentary sovereignty and judicial supremacy. Okay, that means if there is a need to amend the Constitution, then Parliament will come with the laws, and whether these laws are right or wrong is decided by the judiciary. Okay, that is the meaning of the statement. Next we will see the Supreme Court on the other hand has a power of judicial review to declare the parliamentary laws unconstitutional. See, if Parliament comes with laws which are unconstitutional, then Supreme Court has a power to void that laws. Okay, it has a power, judicial review. So it can declare the parliamentary laws unconstitutional. Next, the Parliament on the other hand can amend the major portion of the Constitution through its constituent power. Okay. Next we will see the integrated and independent judiciary. Supreme Court is a federal court, the highest court of appeal, guarantor of fundamental rights of the citizens and the guardian of the Constitution. Right? We all know lower courts appeal to high courts and high courts appeal to Supreme Court. Supreme Court is the highest court of appeal. So it is the highest court of appeal that guarantees the fundamental rights to the citizens and also guard in the constitution. Next, the constitution has made various provisions to ensure its independence. So independent judiciary, we'll see the provisions under it. Security of tenure of judges. There is a security of tenure for the judges. Next, fixed service conditions. All expenses of the Supreme Court are charged on Consolidated Fund of India. Their expenses cannot be voted because they are charged on Consolidated Fund of India. Next, prohibition on the discussion of conduct of the judges. And there is a ban on the practice after the retirement. Next, power to punish for its contempt vested in the Supreme Court. Separation of judiciary from the executive and so on. All these are the independent judiciary. All these are the features of the independent judiciary. Next, we will see the integrated. Supreme Court, High Court, lower courts enforce both union and state laws. Okay, this is the integrated judiciary. Next, we will see the fundamental rights. Part 3 of the Indian Constitution guarantees 6 fundamental rights. Right to equality, that is Article 14 to 18. Next, right to freedom, Article 19 to 22. Right against exploitation, Article 23 to 24. Right to freedom of religion is Article 25 to 28. Cultural and educational rights, Article 29 to 30. Right to constitutional remedies, Article 32. Next, fundamental rights aim to promote the political democracy. Okay, fundamental rights aim to promote the political democracy. Next, fundamental rights are enforceable by courts through writs. Writs, total there are 5 types of writs: habeas corpus, mandamus, prohibition, certiorari, and quo warranto. So we'll see all this in detail in the future classes. Next, directive principles of state policy. So DPSPs are meant for promoting the idea of social and economic democracy. Earlier we have seen fundamental rights are political democracy. DPSPs are social and economic democracies. Next, they seek to establish welfare state in India. Okay, DPSPs seek to establish welfare states in India. They are enumerated in the part 4 of the Constitution. Okay, they can be classified into 3 broad categories, that is socialistic principles, Gandhian principles, and liberal and intellectual principles. 3 categories DPSPs. Next, we'll see the fundamental duties. They are added during the operation of internal emergency by 42nd Constitutional Amendment Act of 1976. Okay, see, originally they were not enacted in the Constitution, but they were added in the 42nd Constitutional Amendment Act of 1976 on the recommendation of Swaran Singh Committee. Originally there were 10 fundamental duties. In 86th Amendment Act of 2002, one more was added. Now total we have 11 duties. Next, the fundamental duties serve as a reminder to the citizens while enjoying their rights. They have also to be quite conscious of duties they owe to their country, their society, and to follow to their fellow citizens. See, fundamental duties mainly they serve as a reminder to the citizens. While enjoying their rights, they have to also be conscious about their duties, okay, towards their country and the society. Next, we'll see the secular state. The term secular was added to the preamble of the Indian Constitution by 42nd Constitutional Amendment Act of 1976. See, originally in preamble, secular was not there, and this secular was added in the 42nd Constitutional Amendment Act of 1976. Not only secular but also socialistic and integrity. 3, secular, socialistic and integrity were added, okay, to the preamble in the 42nd Constitutional Amendment Act of 1976. Next, the preamble secures to all citizens of India liberty of belief, faith and worship. Next, it is reflected in preamble. Okay, the secular state is reflected in Article 14, 15, 16, 25 to 30 and 44. 14, 15, 16, 25 to 30 are fundamental rights and Article 44 is DPSPs. So this secular is reflected in all these articles. Next, the Indian Constitution embodies the positive concept of secularism, that is giving respect to all the religions or protecting all religions equally. See, there are two types: positive secularism and negative secularism. Positive secularism is giving respect to all the religions. Negative secularism is separating the religion. Okay, separating the religion from the state. So Indian Constitution adopts the positive secularism. That is, it gives equal respect to all the religions and protecting all the religions equally. Next, we'll see the universal adult franchise. The Indian Constitution adopts the universal adult franchise as a basis of elections to the Lok Sabha and the state legislature assemblies. So, universal adult franchise is nothing but every person above 18 years of age has a right to vote. Okay, every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth, and so on. Next, the voting age was reduced to 18 years from 21 years in 1989 by 61st Constitutional Amendment Act of 1988. So earlier it was 18 years. Earlier it was 21 years. Now the voting age was reduced to 18 years. So any person above 18 years can vote. This was made by the 61st Constitutional Amendment Act of 1988. Next we will see the single citizenship. Though the Indian Constitution is federal and envisages a dual polity, it provides for only a single citizenship, that is Indian citizenship. See, ours is a union of states, right? Though there are many states, we have only one citizenship. Okay, India as a whole has only one citizenship. Next, independent bodies. The Indian Constitution not only provides for the legislative, executive and judicial organs of the government, but also establishes certain independent bodies. Let us see what are they. Election Commission of India, UPSC, Union Public Service Commission, CAG, Comptroller and Auditor General of India, and SPSC, State Public Service Commissions. All these are the independent bodies. Okay. Besides the legislative, executive and judicial organs in the Constitution, we also have the independent bodies. So all these are the independent bodies. Next we will see the emergency provisions. The Constitution stipulates 3 types of emergencies: national emergency, state emergency and financial emergency. National emergency is declared on the basis of war or external aggression or armed rebellion. So this is declared in the Article 352. Next, state emergency, also called as President's Rule. This is declared on the grounds of failure of the constitutional machineries in the states. Okay, according to Article 356, state emergency is declared on the grounds of failures of the constitutional machineries in the state. According to Article 365, there is state emergency is declared on the failure to comply with the directions of the state. Okay. Next, financial emergency. This is declared on the grounds of threat to the financial stability or credit of India. This was written under the Article 360. All these are the emergency provisions. Next, 3-tier government. See, after center and state, there is one more: local government. Local government. See, 73rd and 74th Constitutional Amendment Act of 1992, it added the three-tier government, that is local government, which is not found in any other constitutions of the world. Okay, this provision was written in our constitution only. Three-tier government that led to the this three-tier government led to the democratic decentralization. Okay. Next, we'll see the cooperative societies. 97th Constitutional Amendment Act of 2011 gave the constitutional status and protection to the cooperative societies. So originally in the constitution it was not there. 97th Constitutional Amendment Act of 2011 came up with the cooperative societies. See, this made three changes in the constitution, that is right to form cooperative societies as a fundamental right, which was included in Article 19. Next, new DPSPs on the promotion of cooperative societies. Okay, Article 43B. Next, it added a new part. Okay, it added a new part 9B to the constitution called cooperative societies. See, from articles 243ZH to 243ZT. All this come under the cooperative societies. With this, we have done with the salient features of the constitution. In the next class, we'll deal with the preamble of the constitution. Thank you.